Right? Thank you. All right, so to have a look at Mallon and the questions, and then to move on and have a look at this article by Easterbrook and Fischel. It's a 1985 article, but I think it just explains the basics of why, the basic rationale for limited liability and why it's here to stay. And it also explains the manner in which insurance fills the gaps where perhaps limited liability might let you down, and also the court interventions with lifting the corporate veil and how that fills some gaps. And finally, I wanted to talk briefly about women on boards and that particular provision, section 149, and have a little bit of a debate about it. So that's the aims of the day. So let me first, oh yes, I don't need to go there yet. Let's have a look at this particular chapter, which is talking about the different types of theories that can be used to understand a corporation. So I'm looking at Mallon from the main reading list, and it's chapter 2 of Mallon's textbook, where she looks at the theoretical aspects of corporate governance. So how do you actually understand corporate governance? Who are the main players? We had a brief look at this last class when we looked at section 172 as opposed to section 164, 172 of the UK code, South African King code, the Indian 164, and also the Australian. So we've briefly examined the way in which this idea is governed. But what's interesting is we are seeming to be moving towards this stakeholder model. So the first principle that she really uses, Christine Mallon uses, is to talk firstly about this idea of agency. I'm sorry, but on the page what I left out was agency. The top thing was agency. So firstly she says that the main theories is developing this idea of agency further. So let me come back to you and ask you about what you understood from agency theory that, hello Judge, that she's talking about.
There might be possibility that agent might misappropriate the part which he has, or he might misappropriate the information from the principal.
Okay, great. So agency is just a way of trying to make contracts work. So a contract between two people is easy, it's straightforward. But a contract where there's a middleman between two people, but the middleman is the facilitator, is what agency theory is all about. And she's saying that agency theory is what is being used to try to explain or build relationships within the company. So that's a great explanation, and thank you for that. So a couple of classes ago, in the first class, we talked about the third party, the principal agent third party. And if you remember, we talked about landlord, real estate agent, renter. The main thing for you to remember is the contract is between the landlord and the renter, right? Just forget that's the main contract. There's a back contract as well, as you would know. And the back contract is between these two guys. Because this guy is appointing the real estate agent. There's that contract. But the main contract is that the real estate agent is developing a relationship with the renter to make a contract between the landlord and the renter. So that is what happens with the company and the third party. The middleman, the officer or director, is making a contract between the company and the third party. For example, creditors, suppliers, anything like that. The contract is between the principal and the third party. What's interesting with agency is, they're just trying to use some existing legal principles, and as we know, contract seems to be the fundamental way in which all commercial law works. So they're using contracts to explain corporations and how corporations work. And it's called the nexus of contract. That there's a contract between the shareholder and the company. There's a contract between the officer and the company. There's a contract between a shareholder and another shareholder. So there's supposed to be all these contracts that are happening within a company. Briefly, however, I wanted to ask you to look a little bit more at the powers of the agent. As you correctly said, where the act that the agent undertakes is done without power, you can argue that the contract is void. So if, for example, the real estate agent, just to go back to the real estate agent, is supposed to rent the landlord's house. Instead, he uses the house for parties and conducts rave parties in that house. So that kind of activity is actually outside the power that the agent has. And if they do that, then there is a breach of contract, okay? Let's just take it further and say that the real estate agent sells it to a renter to conduct rave parties. And it's a residential house in a quiet residential street. So the real estate agent, you could argue, is doing something that he is not allowed to do, something outside his power. Therefore, you could argue that the contract between these two is void. Does that make sense? So to make sure that the contract is binding, the agent must be acting within his or her power. And this is really important with a company. If the agent is not acting within the power, the contract entered into by the company with the third party is void. And the company can actually say, I'm not paying. All right, so the agent can act in a way that binds the company to the third party as long as they act within an actual authority or ostensible authority. And I think you guys must have done all this in contract law, pretty basic. So the actual authority in a company is written in the memorandum. It's also in the contract of employment, and it's also going to be maybe a general meeting gives a specific power. So it could be a general meeting giving a power. Ostensible authority only happens where there's no actual authority. But the person is getting the power from someone with actual authority, and the third party hasn't got any information to the contrary. I think this is pretty easy to understand. And I just wanted to use a quick example to apply this principle. So if I can flick to the next slide. So often little principles like this become clearer when you try to apply them and see how little tricks can be played. So this is a question that I thought you could consider. Manil Rao is the CEO of Pacemakers Limited. Shanti Rao is the wife of Manil Rao. Manil is in hospital for heart surgery. That was very funny, pacemakers, heart surgery. Anyway, Shanti makes all the decisions when he's away for 6 weeks. One such decision is to enter into a joint venture with Cockley Hearing Limited, an Australian company. 1 year after this, it's discovered that Cockley has been, insolvent. Has been insolvent for the last 6 months. Manil wants to minimize the loss and asks you if the JV contract can be void, because Shanti did not have the authority to act on behalf of Pacemakers Limited and enter into this contract. Does that make sense? So the question is there a valid contract between Pacemakers and Cockley? Because of course they know it's insolvent. They don't want to actually get into the contract. They want to back out.
It's a valid contract because it seems to be ostensible from Shanti. It is ostensible.
Yeah. Would you like to elaborate?
Ostensible owner simply means that it seems to be a deemed owner. That if any real owner is not working at the place of the at his work, so ostensible owners can be substitute to that real owner and act as a real owner. And if the act of the agent, that is the substitute agent, substitute owner is the approved by the real agent, then it is said to be ostensible owner.
Let me just change the facts slightly to bring out a point and try to get you to crystallize your view. Let's say that Shanti is actually Manil's mistress and no one knows about her. She's actually a spurned mistress. She's not his current lover. She comes in to the office and takes over. And everybody, or she hacks his account and takes over. Is the company liable?
He's allowed to do the work and make the company decision for last 6 weeks. So
No, would the company be liable? Sorry? Why not?
because Shanti is authorized to do the work. She is authorized to do it.
Who authorized her?
That is his her husband. But she is already taking decision for the last 6 weeks. So it's deemed to be that she is the real owner of that. She is working as the place of the CEO of that. And
What about the mistress? What about the mistress idea? Let's say, okay, let me just make it simpler. Let's say Shanti is actually divorced and she finds out he's in hospital and gets into the building. Then?
Without any approval, if she works, then there is a part contract.
For it. Okay, so good point. But the question is, how do you figure out that she has actually got authority? The main point is acts in the position with approval from someone with actual authority. So that is the point. So is she working in that position and has someone with actual authority given her that? What do you reckon, guys?
No one is, the CEO of the company is not given the authority to the mistress of the company, so the contract is in the...
All right. So I think the point that's being made there, if I could just build on it a little bit more. Usually nobody, a company's a moving feast. Things are being made on the run. So usually they have this thing called holding out. If you're holding someone else out, and past conduct can be seen as holding out. So if in the past she has been making decisions, if in the past she has actually come into the office and taken interest in the affairs of the company, that could be evidence. If also the other thing is, if you give approval retrospectively, it can be seen as giving approval as well. So if Manil, after finding out that his wife has entered into the contract, doesn't do anything about it for 6 months or a year, then you could say they have also accepted the contract because they basically agreed to it. Does that make sense? Given retrospective approval that they entered into it. So, however, if, for example, she's never done that before and he doesn't know about it, then it's murky waters. So, but the main point to remember is giving approval with someone with actual authority can be an act where you say, my girl is going to take care of this when I'm away. It can be retrospective by ignoring it at a later time. Or it can also be that acquiescence. So you can actually allow somebody to keep acting without giving them approval, and just by merely acquiescing to them acting in that way, you're giving approval passively. So that's the way in which you can think about ostensible authority. And therefore, in that case, the JV would be valid. So it just depends on whether you can show those things. So if you're answering a question, or what I would expect my students, if they were answering a question, is to ask for the facts in that problem and to say the facts do not state whether or not Manil has asked her to, whether he's aware of it and acquiesced, or whether there's some kind of conduct, past conduct, that could lead to this conclusion.
Don't you think it's an implied approval by the Manil ma'am, because he discovered the insolvency after 1 year, ma'am. 1 year he is fine with that and doing the business as a JD.
Correct.
So it's an implied of the approval, ma'am, by the side of the Manil.
That's what you'd have to say. If you say that, all I'm saying is that it can't be a gut feeling. You've got to explain why you get that gut feeling. Yeah.
So, as you said, acquiescence is one. And in the first point that Shiva made, that he would be deemed to, be understood as the authorized person, I think is something that is valid in the Indian transfer of property law. From there, I could get from the language where the logic is coming from. So, there, see, both acquiescence is a document way. For individuals, if someone else is acting, so, and there is the transfer of ostensible owner, there is a separate category, right? So there, the law actually, ma'am, without any authorization also, if someone looks as if he or she is the ostensible owner, the transfer done by him or in this case her would be considered to be valid.
No.
But for corporations, it always has to be a board approval or any authority to be given.
In the corporate law, in the old law in 1956, you had a concept of a shadow director. That is a person who had been continually acting as a director without appointment. If the person acted as a director without appointment, they were deemed to be a director. But the provisions currently under the current Act have removed that. And they have said that you have to be appointed as a director to be a director. So the notion of a shadow director no longer exists, except in the case of fraud. So the idea is the shadow director was more possible under the 1956 Act, and under the 2013 Act it seems less so because it's left out. So there's room for interpretation.
They kind of left out the definition itself, but you'll find the reference of shadow director in multiple sections in the Companies Act again.
Maybe for liability or not.
Yes. So again,
You can for liability.
I was wondering in the example that you gave, again, in Indian corporate law, we again have a law scope on two doctrines, the doctrine of constructive notice and doctrine of in-law management. So how would that play out in that example that you gave?
Well, this notion of agency, has been purposely codified. So what I was trying to say is that agency is the basis on which corporations' relationships are built. But what was decided was that as time went on, there was a case called Turquoise versus the Royal British Bank. And in that particular case, it was decided that the actual creditor did not read the memorandum. Okay, so did not read the memorandum. So the point was made that we are going to come out with a rule specifically for corporations. So this principle of agency and these principles of actual and ostensible authority have been codified as constructive notice and actual notice within the context of corporations law, in the common law by virtue of Turquoise's rule, and codified too in the statute. The ways in which it's codified is, firstly, there's no need for you to read the memorandum, but you assume everything in the memorandum is valid and everything in the articles is valid. You also assume that what is reasonable to be expected of a person in that position is continuing. If there is any restrictions that are particular, unless you have notice of it, it isn't valid. You could have ostensible notice, but otherwise it isn't valid. So the Turquoise rule is codifying this in relation to corporations. So let me just move on to this article. So I just wanted to explain that idea of agency a little bit more, and to say that the thing about agency that we've reiterated is that the agent can go nuts, can go crazy. So all the corporation's rules are about controlling the agent. So it's all about keeping the directors controlled. Now, I just wanted to ask you about this transaction cost economics. What you understood from them. Maybe I can go to the questions at the back on page 25. And the first question is, critically discuss the main theories that have influenced the development of corporate governance. The first was agency theory. We've just talked about it. What about this second theory, which is on page 18, transaction economics? How has that become something that is been accepted into our corporate governance literature and statute? Any ideas?
It was quite linked to the agency theory that, so if you are giving some persons the authority to conduct the affairs of the company, then there are certain costs associated with it, including the fact that they will act in their own interests and costs that will be related to policing their behavior. So it is very much linked to the agency theory that there are certain costs associated with managers and giving political directors certain powers to act on behalf of the shareholders.
Okay. And in large conglomerates, the temptation always is to make sure that you function within the company, because it's so much easier if you can just function within the company to keep costs down. So if you're going to go out, because every transaction is going to have a cost. So if you can have a multinational company, for example, and you can make all your transactions in some standard form, or even have a corporation with many bits to it that do all sorts of activities, you don't have to go out and make contracts all the time. So it's kind of explaining the growth of multinational companies and using agency again and saying it's going to be easier. So yes, the next question is, do you think the different theories are more appropriate for different ownership structures? So stakeholder theory and agency theory and transactions theory. We just said that the transaction cost theory suits big structures. Any ideas?
Yes, because there cannot be just one model which will suit everybody from proprietor to a multinational company. There should be a system which cater the needs of these different corporations, I can say, which have different functions and have different internal structures altogether.
Okay.
So just isolating one and saying that this is the best, we would not be doing.
So can you talk about what we were talking about earlier this afternoon, that there are different kinds of structures or different regulatory structures for different types of companies? So listed and... Okay, so I think we were talking before that, yes.
So, for example, the Anglo-American model would fit those countries where the ownership patterns are similar to UK and USA. But for example, in Germany or Japan, where you find a different structure in boards, different structure in pattern of decision making, you wouldn't be able to impose the Anglo-American model there. So we see that there are differences between the way the governance is carrying on, the way the decisions are carrying on within the organization. So, even in the reality of the world, we see that it's not same. And once, like she said, one size does not fit all because of that.
Lovely. We're obviously going to talk about India, and we're going to talk about the concentrated ownership and the importance of family and the difficulty of finding people who necessarily want to query ask questions in companies, the political situation, whether it is fairly democratic or whether corruption is rife. All of those things are going to actually determine company structure as well. So a good point that you've made. So it's not only the economic structure of opening up investment and creating an infrastructure, because I work with the Pacific, in the Pacific, and we're all about trying to introduce company laws all through a number of Pacific countries, but you can introduce them, but no one actually sets it up because it's against the culture of the place. So, you know, so often laws have got to align with culture to be able to take off, is the point that's being made. And thank you for that. Japan, an idea of workers. Germany, a link between banks, always been important in corporate governance. And of course, in UK and US, the masses are very important. All right. So we'll give 3 a miss because we've talked about the principal-agent relationships. So let me just move on maybe to the last question. Critically discuss the role of corporate culture in helping ensure an ethical corporate environment and how it may encourage directors and other employees to act with integrity. So I suppose the question really is, what can a board or what can a general meeting do to encourage ethical conduct within a corporation? I know from yesterday's little discussion we had where you want to dump everything on a community that can't speak, I am wondering about your ethical content. Not yours, don't worry. You spoke up, I remember. But I'm just wondering, if a company does want to actually encourage this, how does it happen? I mean, right now, there's a huge push to invest in responsible investing. It takes up about 40% of the American superannuation funds market and about 20% of the Australian funds market. So there's a big market out there that's investing in companies that are responsible, and people are pulling their money out of tobacco companies. So it's in the interest of companies to actually encourage ethical conduct. So, but how can a company do that? This is just to start you, just to ask you a question about, you know, where do you start? Is CSR a way to go? Mandating. So that's a government doing something. How can a company do something? Go for it, bro.
Basically, we are talking about the ethical responsibility by the directors, how they are conducting. So first we need to look at what is the basic requirement for the employees of that company or corporation. So according to that, the directors have to make the resolution or pass the resolution as per the requirement of the employees and as per the environmental assessment and all these basic, overall the basic thing of the companies.
Okay, so they've got to pass a resolution.
Simple language, ma'am. What is legal, that is moral.
What is legal?
That is moral.
Okay. So you're saying that if it's not in the law, the company isn't going to do it?
I want to say the opposite. What is ma'am legal, that is moral. Where the company is taking ESA, that is environmental impact assessment, and all the requirements which is come from and these are all things which is legal, ma'am. And it is not attached to the integrity of that corporation.
Okay. Ladies? I know you have something to say. Guidelines, affirmative action is some sort of ethical thing. They say having 3 women on the board is important, not 1. Because 1 woman just can't speak up, 3 does, 3 do. Okay, so some sort of diversity.
Transparency, disclosure within the organization, at least some sort of semblance of participation of power so that the employees have ownership over the company.
Okay. So more and more disclosure of conduct to try to maybe attract a consumer base or try to attract financiers who are ethical. Employer loyalty, win the CSR prize. Okay. Great. Let's move on. I wanted to now go on to the article that we were talking about, the Easterbrook and Fischel article, which is in these materials. And I just put some questions up because the article is so dense. I must have read this article about, I don't know, 40 times or something. But because, I mean, through time. And I think the first time I read it, I couldn't really understand it. Around the 20th time, I thought, this is so convincing. So I do understand that, you know, it's a bit of a... Anyway, I'll stop raving on about myself. Now, I just wanted to say why I wanted you to read the article is the fact that it presents... The Chicago School has been so influential in the creation and in the acceptance of the notion of a company. The Chicago School is right-wing economics and right-wing law. They promote everything that is about making the market easy to operate. They very much believe in the idea that everybody is equal, everybody participates, everybody is a rational actor. And the other thing they do is they use economics and harness it so beautifully to explain why some law should exist. But it's not without flaws. So I just wanted you to have a look at it. Anyway, there are some terms that are in it that I thought perhaps need a bit of explanation. T-bills, what's that? Did anyone read it? Cool. I'll stop asking you T-bills. All right. Let me just say it's a really nice article. So maybe I can just explain what it's about a bit. Did anyone really not read? Did anyone actually... I don't want to ask a question. Who didn't read it? Then you all have to put your hands up. Did anyone... Who didn't read it? Okay. Right. Shiva, you read it. You read it. Not participating. Absent director. I didn't do it. Okay. All right, guys. Anyway, don't worry. Okay, so I just wanted to bring it up because what it does is it just tells us why limited liability is so fantastic. So let me just take you through. Firstly, what they say is for a firm, now we know what limited liability is, right? For a firm, they say limited liability is so good for a couple of reasons. Firstly, because it means that a firm can actually attract money from creditors and from shareholders, saying that shareholders won't invest in the firm if they didn't have limited liability. If they didn't have limited liability, the shareholders would be constantly monitoring what the managers do, right? And the managers, they'll be bothering the managers all the time. Let's say that you're all shareholders and you all have unlimited liability. You know that if the company doesn't do well, your every single thing, the shirt on your back is up for the company. So what you're going to be doing is making the biggest pest of yourself, going up and bothering the management and trying to ask them what they're doing every day. Firstly, you won't give the money. Secondly, if you give the money, you'll be monitoring it non-stop. So the notion there is monitoring costs are really high for you, and the company costs, the firm costs, is really high, explaining constantly to you what they're doing. So they'll never take a risky venture. They will only always do something unrisky. And the idea is T-bills, which is treasury bills, which is like your government bonds. That's where you guys will be investing. So the firm with limited liability has access to a huge market because you as shareholders will be wanting to have shares in many firms, not just one firm. Because of limited liability, if you have unlimited liability, you'll be watching, putting all your money on one firm, you'll be going and looking at everything they're doing all the time. You won't have the time, you won't be able to put it in 3 firms because you don't have the time to go and monitor 3 firms. So you keep all your money in one firm. But limited liability means that a shareholder can diversify and invest in many firms. it also means there's a market, a capital market for money. And it means the firms have many people to get their money from. So the advantage for a firm is it can take its decisions without being bothered by shareholders all the time. There are many more shareholders who can give it cash. So that's the main thing. And also the third thing is it creates a capital market, because it creates a stock market where money can actually be freely, shares can actually be freely sold. So that is the term fungible, which is that it can be translated into cash. For managers, it's great because the managers then don't have to explain the decision constantly to shareholders. They have autonomy, they can engage in some kind of entrepreneurial conduct, and it can encourage economic growth activities. If it's unlimited liability, as I said, they'll be constantly responding to shareholders' calls. Secured creditors. Well, secured creditors are fine. They take some of the risk, but not all. Because they secure their asset, they're able to actually monitor only the asset, not all the activities of the company. So the secured creditors can just simply take a charge and they can just monitor that particular asset. And usually the secured creditors are banks and financial institutions who know how to monitor. They have the know-how, so the cost is low for them. It's not high, as for somebody like you who doesn't know how to monitor. Get the annual report, sit there and... Unsecured creditors, well, the answer to unsecured creditors is tough luck. Unsecured creditors are actually getting a high interest. So they're making a trade-off. Unsecured creditors are deciding that they are going to charge a higher interest by lending to a more risky company. And that's fine. That's a decision they have to make. And they take the risk, but they're getting money in return, which is higher interest. So I've left shareholders out there. I'll come to them. The shareholders get wiped out first, but the shareholders have lower monitoring costs. Let's just say that you're all shareholders and it's unlimited liability. You will be monitoring the company, but you will also be monitoring every other shareholder, because you want to make sure that every shareholder is richer than you. Because when the company goes broke and the creditors come for money, you want to make sure that the other dudes are able to pay, right? So your monitoring is like, whoom. You're going to be monitoring yourselves, you're going to be monitoring your friends, you're going to be monitoring who they marry, you're going to be, because they'll be taking the money away. You'll be monitoring, you know, their businesses, you'll be monitoring the company. You'll be so scared you can't move. So the costs then for you are lower, you can diversify. So monitoring costs are lower, diversification is higher, and you also have a fixed return, and you have very little to lose, which is just your share. And if you diversify, one company goes down, likely chance the other company's okay. Tort victims. So Bhopal, so all those tobacco victims, asbestos victims, all those victims. So far we are mainly looking at human beings, but maybe things will change. So for tort victims, what's the story? Well, that's where they are actually saying the limited liability comes with, the company, corporation's veil can be lifted. And the corporate veil can be lifted in certain instances to attach liability to the people behind the company. So you can actually have liability attached to the officers of the company in certain circumstances. Now, the United States legislation, which is where they base their article on, has got some very interesting provisions which we don't have in the common law countries. One of those is actually undercapitalization, which is dealt with on page 113 of that article. So undercapitalization, if a company actually sets up with low capital, unable to, and it knows that the capital is so low that it won't be able to fund the activities it's getting into and won't be able to cover the losses that might result, the corporate veil can be lifted in the United States. That's an incredibly advantageous thing. However, it's not necessarily the case in Australia or, of course, here. So here, how can the corporate veil be lifted? So, oh, sorry, just to come back. So they're saying tort victims can take advantage of the corporate veil in the United States, and also they're saying that you can take advantage of insurance. So they're actually saying that wherever there's a gap, so where the managers want to engage in highly risky conduct, they can take insurance, and that'll kind of cover them. So directors now have insurance, auditors have insurance, and they can also take insurance for doing deep sea mining, for coal activities, anything against environmental damage. And that means that will cover where the limited liability is short, doesn't cover. That's their argument. It's really persuasive. And I just wanted you to read it to see why it's kind of such a strong argument, and the way they talk about how limited liability is the reason for capital markets, is the reason for increased investment, and without it, the whole world is just not like it can be. So anyway, let's just look at the lifting of the corporate veil. Under the Act, you used to have this notion of fraud, of course, and you have this tax evasion cases that I have looked at that seems to be in your law. So there's a case, Dinshaw Manekji, and it's just a case basically of a guy who just tries to use the companies to get rid of income tax. He tries to get it as a loan from a group of companies so that he doesn't have to pay income tax. So clearly that's tax evasion, so that's going to be lifting the corporate veil, and that was lifted. Another case, Guildford Motors. It's a case where the individual actually was a director of a company, and he goes off and sets another shell company and steals all the clients. A regular commercial practice, obviously, which is why they have a clause in employment contract saying you can't. There too, they reckon that the whole idea of setting up this company was a fraud. So the company was a fraud, so lift the corporate veil. Another case, Workman versus Associated Rubber Industries. The company created a subsidiary, transferred all the assets to it so it didn't have to pay bonuses to its employees. Again, corporate veil. So they're the kinds of cases where the corporate veil has been lifted and the liability has been brought back to the parent company. So what we're talking about in the first two cases I mentioned, Guildford Motors and this Dinshaw case, is an individual liability. But in the latter case that I mentioned, Workman versus Associated Rubber Industries, it's a parent company and a subsidiary company. So there, whether the parent and subsidiary company liability can actually, and the veil can be lifted between them. Well, there's a general provision, 447, within your Act, the current Act, which seems to say that, you know, fraud can actually, in relation to the affairs of the company, which includes any omission, abuse, connivance, deception, etc., to cause harm. So it is, however, including the words intent. So presumably that isn't as simple as a tortious breach. It's still got to have some kind of intent in it. So anything like that can actually end up causing some kind of action or resulting in some action. I'm not saying this is lifting the corporate veil, but in a way it can have the same effect. So the way in which it could work is if a person gives the wrong information to register the company, you can actually say that that person's caught. So if you're going to be inducing some poor potential shareholder to invest money and lie to them, that you're actually engaging in sustainable energy and you're actually not, or renewable energy and you're not, you're engaging in petroleum, you can be caught. The promoter or the officer can be caught. Similarly, directors and management can be caught where it's fraudulent purpose. Where the example you gave before, in a couple of last class maybe, of the director or the officer giving incorrect information to the auditor to cover the back of the company, they can be caught. And defrauding the creditors, they can be caught. So there's a possibility that you can go, the Act goes much further than the corporate veil lifting and allows for this to happen. So all I wanted to say here in this case is the main area where we were talking about in Easterbrook and Fishel, the people who miss out is the tort victims and the unsecured creditors. So the question really is this idea of lifting the corporate veil and the notion that you can get insurance sufficient protection for them? Does that balance the costs of them losing out with the benefits that limited liability can bring? And that's a question to you. Anyone?
Done some fraud or he has evaded some tax. But what about the person who has suffered the loss? How can we suffered the loss? Like the creditors, the unsecured creditors. How can we this whole condition invisible? So by lifting the corporate bill, we can only help the person liable who made some fraud or evaded the tax.
Okay, so if you lift the corporate veil, what can happen is that the person who actually committed the breach has to pay, firstly they get a fine, and secondly they have to pay compensation, and that could be from their personal assets. So that's the idea. But I do get your point, and I think you could build on your point, that the company in these instances usually has no money, and the directors in these instances usually have no money, because they have clearly made sure that they won't be ripped off. Ripped off isn't the word, I mean pay their dues is a better word. They've set themselves up in a particular way that they will not suffer this indignity. So yes, class actions is of course a possibility, but gosh, the Indian court system's fabulous, so I mean, who knows if you actually will get any. Yes, it comes with costs. Usually the thing that lawyers should tell their friends, I mean lawyers should tell themselves, is never go near a lawyer, right? Because it's so expensive. But they shouldn't tell their clients that, obviously. Okay, everyone. What did I put this up for? Oh yeah, liability. So who can be liable for the 447? So the auditor, they can all be liable. And the class action is possible for a shareholder if they wish, if they can. But it's very difficult.
Just to share an example with
Yeah,
you,
please do.
If you see the definition of officer in default under the 2013 Companies Act, so funny, it says any director who's acting in, the word connivance used in 447, fraud is also used there. So any director acting in connivance. So if suppose any resolution is being passed and I oppose it in principle, so unless I keep on banging the desk till the end, I will be considered as if I am under connivance. And then 447 hangs on my head. It's a very, those who are reading it, please read it carefully. It's not a very happy officer.
True.
Just a comment. With respect to your lifting corporate veil, so in India, probably we have followed UK all these years. But again, if you see, get into lifting corporate veil against a Pandora's box. There's no uniformity in the decision of the cases, be it any phase, 70s, 80s, 90s. There has been some kind of uniformity on the fraud cases, but when you talk about other aspects of lifting corporate veil, like UK, there is no uniformity. So is it the same in Australia also? So for example, in UK, recently there was a case in 2013, Press vs. Petrol, where the UK Supreme Court actually agreed to the fact that we have not been uniform. And all the cases that have been decided earlier are actually not lifting a corporate veil. And today what we are deciding is lifting our corporate veil or not. So just trying to figure out, is the same thing happening in Australia, or do they have a uniform principle on lifting corporate veil?
No, it's much like your provisions. The common law of lifting the corporate veil that applies here applies in the Australia as well. There have been certain instances where there's been huge tort losses. One particular one is with asbestos, where many people suffered dreadfully. But unfortunately, well, and of course the company left the country, but the chance to lift the corporate veil was there, but they decided rather than lifting the corporate veil, they would decide the case on the basis of tort. And the basis... a CSR versus REM. So they decided that the court decision would be made on tort. So the tort being the duty of care that a company might owe to the purchasers of the product, and has that duty of care been breached because of supplying a product that has dangerous effect. And they were not guilty of that because there was too much of a... it wasn't foreseeable because it was sold in the 60s and the damage wasn't really realised till later. So anyway, but the company that did do the greatest damage, James Hardie, left and is now, I think, selling all through South America, and it's based in Europe. So in answer to your question, and what happened there is the government picked up the tab. So in answer to your question, no, there is no uniform approach because they feel that actually having a uniform approach to raising the corporate veil and threatening somebody may actually threaten the very basis of the company itself. So it's only these red-hot cases like fraud that you can easily kind of decide on morality, but you can't shake the actual foundations. And of course, creditors are an exception because they have their own position in the Act. Does that answer the question? Now, what was I going to do? Oh, yeah. Oh, yes. So I was going to move on now to women on boards and ask you about that. Oh. So just basically there's a section, as you most probably all know, section 149, that every company shall have a board of directors, and as you know, most probably the 3 for public, 3 to 15, and 2 to 15 for private, and 1 and 1 for single, and at least one woman according to the rules. And the rules are that it's a listed company or it's a paid-up company having a paid-up share capital of 100 crore or a turnover of 300 crore. So this is the sorts of companies. They're not talking about small companies. They're talking about large companies with most probably a dozen directors where they're saying you should have one. So I thought this is a good thing to consider right on the back of Easterbrook and Fischel, which is all about economics and profitability and risk. Asking whether having this rule actually is good for the company or not. So I thought we could have a look at this question as a little debate. And I thought that half the class could take one side and the other half another, and I've already elected my judge. And maybe you should do you think you should ask a male colleague to be a judge with you? Nah, don't worry, they haven't asked us for ages. Why start now? Why should we do it? Okay, so only joking. It's a joke, it's a girl joke. Woman jokes. Okay, so this is the thing. So what do you reckon? Should we do that? Or you'd rather go home? No, of course you won't. You don't want to. All right, so how about, you can take a walk if you want. To discuss. How about, I haven't met you before. How are you? Great. So, shall we have this? Oh, you two can. You two don't have to participate. So maybe you guys, and maybe you, and maybe you two. So you 1, 2, 3, 4, 5, 6, 7, 8 in one group, and 1, 2, 3, 4, 5, 6 in another group. Maybe we'll put him in your group. Okay, so you can join them. 1, 2, 3, 4, 5, 6, 7 in one group. 1, 2, 3, 4, 5, 6, whatever. You know what I mean. Great. So, oh no, you're not. You don't have to participate. But you can just walk from one to another, seeing they're doing a good job, police them. So, what do you want to be? Yes, do you want to go for Padma or do you want to go for Ravi? Padma. Okay. You guys are going for Ravi. Against the rule. So, what about 10 minutes to consider? Thank you.